Welcome to our UK employment law and HR look ahead to what SME employers can expect in the UK from 2024. Now, whilst we're expecting various amendments to the Equality Act in January, I'm actually going to skirt around most of those because they're mainly tweaks to the existing legislation. They widen some of the definitions, for example, the definition of disability, and they clarify certain protections, like confirming breastfeeding is protected under the characteristic of sex. I think a lot of employers, or certainly HR practitioners, would have thought it was anyway. Of more interest and impact to most SME employers, I think, will be the changes coming to holiday pay, the national minimum wage, redundancy protection extensions, a new duty to prevent sexual harassment, flexible working, carers leave, this is a new right being introduced, and changes to TUPE. Quite a long list, but I'll cover each change and its impact very briefly in this update. Before doing that though, I'm minded there are two topics which could significantly impact employment law and the employment landscape more generally. 2024 will of course be election year, and whilst that might bring a change of government which will impact employment law, we also have the looming spectre of artificial intelligence, and that could change the future of employment as we know it. Let's start with the potential change of government. Now, Labour, who many predict will win the next election, have published a green paper on employment. It's called A New Deal for Working People, and in that they set out their new approach to employment rights. Amongst the changes are the introduction of European-style fair pay agreements, which will introduce minimum terms and conditions of employment on a sector-by-sector basis. Also, the harmonisation of worker and employee status into a single category, and the widening of day one employment rights, including the right to claim unfair dismissal. Also detailed in that paper are various measures to improve access for trade unions to be able to mobilise and organise labour. Now, many employers, even those fed up with the current government, will shake their heads in disbelief at what they believe to be yet more interference in the employment market, presenting new hurdles, more red tape and more risks for employers. If you want to read more about Labour's proposals, please go to www.myHRdept.co.uk and open our news pages. We've written extensively about Labour's proposals in recent times. Now, on artificial intelligence, earlier this year, Greg Jackson, who's the CEO of Octopus Energy, wrote in the Times that his AI chatbot was responding to a third of his customers' emails, effectively doing the work of 250 people. Customers said Jackson gave an average 80% approval rating of their experience with the chatbot, and that compared with a much lower 65% rating given by customers to their experiences with real, experienced, trained people. It's very clear that AI is capable of doing a great many jobs in the economy currently carried out by people, and it's also often capable of carrying out those tasks better and more safely. Given a free rein, AI could cause the sort of unemployment that could completely change the employment dynamic. For the last few years, the UK has been in high employment, with employers competing for scarce applicants, and unfilled jobs on a monthly basis have regularly exceeded 1 million. Employees' expectations of employers have consequently been very high, and our reaction to COVID has created new expectations of flexibility too. And that's also been seen to cause steep wage inflation, these things. If AI is allowed to reach its true potential, the future may see the balance of power in the employment relationship swing back towards employers as more candidates chase fewer jobs. But will the government, in particular an incoming Labour government, try and stop AI in its tracks? The Labour Party's main backers, the trade unions, are no fans of job-threatening technology, and they'll seek assurances and try to reach agreements that will preserve jobs over the technical advantages that AI can offer. Labour could well find itself in an invidious position. On the one hand, wanting to harness the economic benefits AI could bring, but on the other facing escalating labour disputes brought by the very trade unions the Labour Party was instrumental in strengthening. With the pace of development of AI technology and an election around the corner, I think this conundrum is a lot closer than we may think. So there may indeed be trouble ahead. Placing the crystal ball to one side for a moment, there are some things we know or nearly know will manifest for employers in the coming year. And as usual, most of those changes will happen in April. But first, a reminder of changes in the prevention of illegal working regime in January. So in January 22nd, I think the date is, in 2024, a new code of practice on preventing illegal working will come into place, and that new code will come in with increased fines, steeply rising to £45,000 fine for the first offence of employing an illegal worker, up to £60,000 per worker for employers who are repeat offenders. Employers really should review their policies and procedures to ensure compliance with the new code, and of course we'll be very happy to help you do that. Moving on to April, we're going to see changes in holiday pay calculations, and rolled up holiday pay will now be permitted. So that will be permitted for certain workers, primarily those with irregular hours or who work part of the year only. Alternatively, if they don't want to roll up holiday pay, employers can opt to calculate holiday pay for those workers at 12.07%, and that will be applicable to all holiday years from the 1st of April 2024. Now, these changes largely stem from a strange case law decision that resulted in some part-year workers receiving proportionately more holiday pay than their full-time counterparts. Now, many employment and HR advisors encourage their clients to adopt convoluted formulas to accommodate the impact of that case. Actually, at my HR department, we took a different tack, and we recommended that clients continue to use 12.07% as the calculator. We predicted, correctly as it happened, that legislators would fix the problem caused by that case, and that will be fixed from April. Historically, rolled up holiday pay, where an employer pays a supplement for holiday as opposed to workers taking periods of paid holiday, has been unlawful. The decision to permit it in the case of part-year or irregular workers is a sensible step. Also in April, we're going to see increases to the living and national minimum wage. For the first time, the top rate, the national living wage rate, will apply to workers aged 21 and over. It was 23 and over. A couple of years ago, it was 25 and over. That rate will increase by 9.8%, up to £11.44 an hour. Now, other rates will actually increase by up to 21.2%. For employers who pay the minimum wage for, in particular, a young workforce, 2024 is going to prove to be a very expensive year. To see all the new rates, and you can either watch it on our video or read the article, the link is on screen there. Okay, there's also going to be a new right to carers leave coming in. So, new right for employees with dependent care responsibility. They'll be able to take a week's unpaid leave each year to provide or arrange care for a dependent. The leave is unpaid, and the employer can postpone it if the timing of the requested dates would cause operational difficulty. We're also going to see changes to the enhanced protection from redundancy legislation, which applies currently to women on maternity leave. Now, women on maternity leave are given special protection from redundancy, but from April 2024 that's going to be extended to include the period of pregnancy prior to maternity and for 6 months following their return to work after maternity. And similar rights would extend to adoptive parents and those taking 6 or more consecutive weeks of shared parental leave. We'll also see changes to the right to request flexible working regime. So currently, changes to request flexible working apply to employees with 26 weeks service. From April, it's going to apply to everybody from day one. from all employees from day one. And whereas at the moment employees are allowed to make one request in a 12-month period, that will double. So they'll now be able to make two. If one's refused or they want to change their working arrangements again, they can make two applications in a year. There's a requirement written into the new regs for employers to consult with employees if they're thinking of refusing the request, and the period in which an employer has to respond to the request will reduce from the current of 3 months to 2 months. We'll also see the removal of the requirement for employees to set out in their request information about how they think the employer can accommodate it. Okay, so moving away from April and to later in the year, in July we're going to see changes to TUPE regulations, and we're expecting them to be amended to allow for employers who have less than 50 staff or employers of any size who are proposing to transfer less than 10 staff to consult with employees directly. Under existing regulations, employers often have to elect representatives for this purpose. Although again, at my HR department, we've always adopted a more pragmatic approach when advising clients on small scale or low impact transfers. Around September, we're expecting a new right for employees with unpredictable terms and conditions, so many 0 hours workers would be included in that category, to apply for greater predictability of, in particular, working hours, but other terms and conditions as well. And in October, we're expecting a new duty on employers to prevent sexual harassment. The national press, and indeed us at my HR department, have been featuring numerous articles throughout the year on sexual harassment cases, high-profile sexual harassment cases. Sexual harassment is nearly always committed by older, more experienced males on younger, junior female staff. Not always, but nearly always. So in October, we're expecting a new statutory duty on employers to prevent sexual harassment, and should they fail to do so, any tribunal award made could be uplifted by 25%. Now, throughout the year in 2023, we've released training and communication materials to enable my HR department and JCHR clients to quickly and easily help raise awareness of sexual harassment. Our videos and our resources have been accessed thousands of times and will remain free for our clients to use. And we'll be issuing refreshed versions for 2024 in good time for this new duty. Okay, we don't have a date yet for the next one, so sometime in 2024 we're expecting a 3-month statutory cap on non-compete clauses. Now, these clauses are often feature in restrictive covenants contained in employment contracts, and over recent times we've been advising our clients to move towards shorter restrictive periods which are more likely to be enforceable. We also don't have a date for the code of practice, a statutory code of practice, which we're expecting in 2024, and this will be of interest to our licensed retail clients. It's the Employment Allocation of Tips Act 2023, so it's the code that enacts that effectively. It's designed to ensure that 100% of tips are distributed fairly and transparently among workers. So we're awaiting that code. Don't know what it says, but we'll update you when we know more. Employment law and employment practice are evolving beasts. My HR department, who also provide HR support services via JCHR's combined payroll and HR outsourcing services, offer help with all employment law matters, but better still, our packages include full HR outsourcing, including drafting and maintaining employment compliance, that's contracts and policies, case management, and HR administrative support as well. Our clients include smaller SMEs who outsource all of their HR and payroll requirements to us, and larger clients who outsource employee relations and employment law matters, and who rely on our advisory services to help and guide their internal HR teams. For a no-obligation assessment in 2024 of how partial or full outsourcing could help your organisation, please contact us and we'll be happy to arrange a Teams meeting or attend an in-person meeting if you prefer. And on that note, from all of us at my HR department, we wish you a happy new year.